It's 25 years ago that the Aarhus Convention was adopted. And this report, following on from the influential Pillars of Justice 1, provides a highly significant and I think impactful set of findings and also recommendations aimed at countering the clearly chilling effect of current judicial review rules. As Eleanor Sharpston said, in the case of the UK, there's been little forward progress and much backsliding. To understand the severity of the circumstances of this state of affairs, we're very grateful, all of us I'm sure, to the Environmental Law Foundation, Friends of the Earth and RSPB, all organisations which have worked tirelessly over many years to identify and seek to remove barriers and impediments to environmental justice. I want just briefly to say some specific thanks though. Firstly, we need to acknowledge the mastermind and driver of this project, Carol Day, wearing her RSPB hat. Carol has dug really deep into the statistics, persevered with searches when needed, which I think was quite often, and also undertook considerable detective work to fill in the gaps. As always, and this is deeply impressive, keeping in mind the overall big picture, the trends, the reasons, and the future developments. And I always admire people who can work on those different levels seemingly easily, and Carol does that superbly. Carol was helped hugely by Hannah von Minden, who devoted a great deal of time and energy during her master's degree at UCL to help crunch the numbers and help provide the material for analysis. Stephen Tromans KC provided expert legal knowledge, counsel and insights, as he always does in the writing of this report. So many thanks to Stephen. Huge thanks to Emma Montlake and Tom Brennan of ELF, who have reached for us behind the statistics to highlight cases in which that chilling effect, the real fear of financial ruin, has such damaging consequences for claimants and community groups in their bringing of cases. Their case studies, born from very close work with communities, makes vital reading. We're also very indebted to Katie DeCower and Flora Hauserman at Friends of the Earth, who have focused on what these findings mean for public participation. I hope I'm giving an impression, it's a very real impression, that this report is the product of a great deal of collaboration, both in terms of its research and its writing. So let's move to the agenda. We've got quite a good full-packed agenda over the next hour and a bit. Firstly, Carol is going to take us expertly through the findings and recommendations. Second, Emma is going to provide insights from the case studies, and Katie Cower is then going to follow up with insights on public participation. We will then have, if I've done a good enough job of chairing, a good chunk of time left for questions. So over to you without further ado, Carol. Thank you.
Thanks very much, Jane, and thanks for such a kind and insightful introduction. That's really good, and it means that I don't have to do any of the thanks, which is marvellous. I think I'm ready for the slides, Emma, if you can put them up for me. Sorry to be an infandel, everybody. I couldn't get PowerPoint loaded on my iPad. Anyway, here we are. So yes, the report that has been produced by ELF, Friends of the Earth and RSPB. Now, what this report does is update a previous report that we, Friends of the Earth and RSPB, produced in 2019 called A Pillar of Justice 1. And the point of that report was to look at the trends behind environmental judicial review and what impacts legal reform, particularly, well, legal reform generally, but also legal reform within the field of the Aarhus cost regime is having on access to justice in England and Wales under the Aarhus Convention. I think the report is now up on the websites of the three organisations involved, but I guess we can possibly also just send a copy out to everybody who's listening into the webinar today, but it is online as I believe it. Next slide, please, Emma. Now, as mentioned, the purpose of the report is to drill down into the issue of environmental JR, but particularly to look at the issue of prohibitive costs, the very high cost of legal action in the UK, and that's a requirement under Article 9.4 of the Convention. The timing, why are we doing this now? Well, many of you will know that the UK is in breach of the prohibitively expensive provisions of the Aarhus Convention. It has been since 2010, in fact. And on the 1st of July last year, the UK government published an action plan. It was required to do this as a result of a decision made by the meeting of the parties to the convention. And the purpose of that action plan was to address the issue of prohibitively high costs in the UK. Now, as I say, that was published a year ago. And since then, we haven't had any action. The main component of that action plan was to actually undertake a review of the Aarhus cost regime to see how it was working. That, as I say, hasn't happened yet. We're hoping that's going to happen very soon. It has to happen by the 1st of October of 2024. So the idea behind this report is that we can feed into that review of the Aarhus cost regime and hopefully inform the outcome of it. So let's just sort of look at just in terms of what it's based on. The report is based on data from the MOJ obtained under environmental information regulations, and it looks at the period between May 2019 and July 2022. It also draws on the quarterly statistics published by the MOJ and some of the data from Pillar of Justice 1. And as Jane kindly mentioned at the beginning, we're very grateful to Hannah von Minden, who's a postgrad student at UCL, who's crunched the data for us. Now, the report covers 4 areas I'm going to talk about briefly today. Firstly, what's happening with the number of environmental JR applications. Secondly, the number of applications that are successfully challenged by defendants as Aarhus Convention claims. Thirdly, what happens in terms of the percentage of cases in which permission is granted. And finally, the percentage of cases that are ultimately successful for the claimant. Next slide, please, Emma. A couple of caveats I have to put in before we start. And that's that, sadly, the MOJ does not have a transparent and consistent sort of really kind of any system for identifying the number of Aarhus Convention claims issued annually. They do have some software which recognises particular topics as potential Aarhus Convention claims, and so some of them have gone unrecorded. So the information we got from them, we noticed that some of the cases that we ourselves had taken weren't on the list. So we did as best as we could to contact major NGOs, major law firms active in this area in terms of cases that they've taken in that period. And any that were missing, we sent to the ACO and they were able to add them into the list. So we have to say that we're pretty clear this data is not complete, but we've done the best with what we can. And we're very pleased to say that the MOJ has said they are going to be introducing new software soon that will hopefully be able to enable us to have a sort of a proper identification of all these Aarhus Convention claims, and then we really will be able to speak with real confidence about the findings. Just to also say that the periods for Pillar of Justice 1, which covered 2013 through to 2019, and Pillar of Justice 2, which was 2019 to 2022, they're not of equal length. So you'll see the graphs, there's a lot of variation. The really important thing to note is the general trajectory, the general trend of what's happening here. And what we've tried to do occasionally where we can is we've compared what's happening with environmental cases with judicial review statistics more generally, and that gives us some interesting results as well. Next slide, please, Emma. So firstly, to start with the number of environmental JRs issued per month. This is data for Pillar of Justice 2. You can see there's quite a lot of variation between sort of roughly 7 up to peak of nearly 10 down to 4 cases issued per month. So what we've done in most of these cases is just take an average because of the variation, and it's around about 7 cases being issued per month, which gives you for that Pillar of Justice 2 period around about 84 cases per year. Next slide, please, Emma. Now, if you look at the data for Pillar of Justice 1 and Pillar of Justice 2 combined, the Pillar of Justice 1 data is blue, Pillar of Justice 2 is red. Again, as you can see, it jumps about a little bit. So we're looking at the general trajectory here, and you can see that there has been a decline over that decade period. In the first area of Pillar of Justice 1, it peaked at 15 cases a month, but the average works out at about 140 cases per year. And as I said before, for Pillar of Justice 2, we're looking at around about 84 cases per year. So there has been quite a substantial drop in cases from when the data was started to be collected in 2013. Now, really, the forthcoming review of the Aarhus cost regime is obviously an opportunity for the MOJ to uncover some of the reasons for this decline. But it seems fairly obvious to us that some of the legal reforms that have been introduced really with the intention of actually dissuading people from bringing jail applications. The government has been quite open about the aim of some of these reforms are indeed having that effect. And I'm not going to go through those legal reforms in a lot of detail. There's been quite a few over the last decade. Just to sort of headline them, we had the Criminal Justice and Courts Act of 2015, which made substantial changes around the no interest test and also changed the cost regime for interveners. I think it'd be very interesting. We haven't looked at interveners, actually. It'd be interesting to see what's happened to the number of interventions in cases since those reforms in 2015. We've also had reforms to the environmental cost regime itself that were introduced in 2017. The most significant of that was the ability to vary the cap, the cost cap that the claimants benefit from. Before 2017, they had been fixed at £5 for individuals and £10,000 in all other cases. And the biggest change of those 2017 reforms were that those caps could be varied at the application of the defendant. At that time, it was just the defendant. And as a result of that, there was an obligation on claimants to provide a schedule of financial resources in order to inform the defendant as to whether they would make an application to vary the cap. We then, following that, had the independent review of administrative law, which was followed by a government consultation, which led to the Judicial Review and Courts Act of 2022, which introduced two new remedies in JR, suspended quashing orders and prospective quashing orders. Too early to say what the impact of those are, although I do know one case in which those are already in play. And we've also had a number of case law developments throughout that period. A couple of recent cases which are quite significant are Burton Cheney, which enabled clarified in the High Court that the interested party has standing to apply to a variation of the cap, and CPRE Kent, in which the Supreme Court held that when permission is refused, the claimant may be liable to pay the costs of more than one defendant or interested party. And the report goes into a lot more detail about what the possible consequences of those changes might be. Just to finish off on this slide, the assumption that those legal reforms are having the desired effect is really borne out by ELF's experience and the case studies that they have got in the report. We've got a section in the middle where ELF reports back on some of the findings from individuals who've been deterred from taking legal action. And I think Emma's going to talk about that later, which would be really great. Next slide, please. Now, I won't go through these in a lot of detail because there's a few of them, they are discussed in detail in the report. But in terms of addressing the falling number of Aarhus Convention claims, there are a number of things that the government could do. We've pointed them out to them very many times. And in fact, they've been pointed out to them by the Aarhus Convention Compliance Committee as well. In the report that the Compliance Committee submitted to the 7th meeting of the parties to the convention, they ran through in a lot of detail some of the measures that the UK government could consider introducing. And many of those push back directly on the reforms that have been introduced over the last decade. So just to pick out a couple of these, really the inclusion of all environmental claims, not just JR and statutory review, but civil and private claims within the scope of the Aarhus cost regime. That's a very obvious recommendation. It was a finding made by the Compliance Committee in 2015 and hasn't been implemented at all since then. One of the things we're also asking the government to look at is looking at the adoption of the Northern Ireland cost approach. Now, in that system, the default caps for the claimants can only be varied downwards. They can't be varied up. And the reciprocal cap for defendants can only be varied upwards. So it has all the best elements of the scheme, if you like, without any of the drawbacks, in the sense that claimants have certainty about the absolute level they're going to be facing in terms of adverse costs, and that's £5,000. But if they are successful, they can actually hopefully recover the full amount of their costs. And we've got some other findings there, pushing back on the court finding in Burton Cheney, and also making sure that we all know that the cost cap applies to all stages of the legal process, not just the High Court first instance days, but also Court of Appeal and Supreme Court stages as well. Next slide, please, Emma. And just a few more here that we've outlined. Again, as I say, these are all in the report. They're discussed in some detail. Really getting rid of the requirement to provide a schedule of financial resources, unless, of course, you're looking to reduce the cap, in which case you may wish to provide information to apply for a downwards level of the cap to be set. making sure that the figure of 5 or 10 applies to the actual claim and not to the number of claimants. As many of you will know, each claimant at the moment attracts its own cap of 5 or 10 as opposed to the claim as a whole. Also some changes around interveners, so that they can benefit, interveners who intervene in support of the claimant can benefit from the Aarhus cap. At the moment, it's only defendants who can benefit from that. And then a couple of other things as well. But the most important, I just wanted to say briefly at the moment, relates to the reciprocal cap. And really, we would like to see the reciprocal cap on Aarhus Convention claims removed. There's no basis for the cap in the convention at all. I think it was introduced by the government notionally to bring some fairness to the procedure for defendants, but we know that fairness in the Aarhus Convention relates to what's fair for the claimant and not the defendant. That's been clarified by the Compliance Committee before now. Next slide, please, Emma. Moving on, some of these other areas are going to take, no, don't worry, they're not going to take as long to go through as that one. So the number of applications that are successfully challenged by defendants as Aarhus Convention claims, just starting here with the Pillar of Justice 2 data, we had 28 cases in which the cases were challenged. One of those was successfully challenged in the first set of data, but after that, the other 27 were unsuccessful. Now, a caveat here we need to make clear is that the MOJ couldn't clarify that the number of cases in which an application to vary the cap was made didn't also cover the applications to vary the cap. Apparently they can't differentiate between those two categories. So what could in fact be happening here is this is taking in some applications to vary the cap as well. And obviously that's making it very difficult to understand what's really happening. But if we take it at face value, it suggests that defendants may be using this provision of the CPR disproportionately. Next slide, please, Emma. And when we look at the combination of Pillar of Justice 1 and Pillar of Justice 2 data, you'll see that there was a very high peak in the Pillar of Justice 1 data of the number of claimants wanting to challenge the status of claims as Aarhus Convention claims, and then it fell very steeply. And we didn't feel able to draw any conclusions from that at the time. We felt it could have been a blip in the data. It was such a steep fall, but that decline has been carried on through in the Pillar of Justice 2 data. Next slide, please, Emma. So what seems to be happening is that we have got a substantial drop in the number of successful claims to the status of claims as Aarhus Convention claims. Now, what might be behind that? Why might that be? Well, as we know in 2013, or many of you will know in 2013, there was a much more rigid approach to costs for defendants who challenged the status of claims before 2017. Originally, if a defendant unsuccessfully challenged the status of a claim, they were subject to indemnity costs. Now, in 2017, that regime was relaxed to sanction to it now just being a standard cost assessment and not an indemnity cost assessment. Now, the Compliance Committee at the time said that they thought that would lead to an increase in the number of challenges, which we did see, and they said that that would have an unhelpful effect on claimants. And we did see that, as you'll see from the data before. We saw a significant increase in the number of successful challenges to begin with and then falling off. Now, one example of this I've given here is the Friends of the Earth case of UKEF, in which UKEF argued that its decision to provide over £1 billion, or $1 billion, I'm sorry, of taxpayers' funding to a gas project off the coast in Mozambique was not an Aarhus Convention claim on the basis that it was a financial decision and that it actually was taken under the obligations under the Paris Agreement. Now, the judge in that case disagreed with that and the cap remained at £10,000. And from what we're seeing, that was the case in 27 of 28 of the challenges. So it would seem that there is probably a questionable basis for retaining a regime in which defendants are, on the whole, unsuccessfully challenging claims, and particularly to have costs being changed to a standard cost basis assessment. Next slide, please, Emma. Moving on to the number or the percentage of claims being granted permission to proceed. This is a really interesting area. This is a combination of Pillar of Justice 1 and Pillar of Justice 2 data. And you'll see that it's wiggled around a little bit, but it's remained fairly constant at round about 35% of applications made eventually getting permission to proceed. And of course, everybody be aware that there's 3 bites of the cherry there. You have permission being decided on the papers, you have an oral renewal hearing and a Court of Appeal hearing there. We did a comparison here between environmental JRs and JRs more generally, and we found that the permission rate for JRs more generally is around about half the rate of that for environmental JRs. So that is an indication that environmental JRs are doing very well. They're not being bought for unmeritorious, vexatious or frivolous reasons, as would be believed if you read some of the opening ministerial statements in some of the consultations that have been taking place over the last decade or so. Next slide, please, Emma. But there is a very interesting thing happening at the end of the data for Pillar of Justice 2. Now, we don't know whether this is a blip again, so we have to caveat that with the fact that we should now, I think we've got another year's worth of data that we could get. So I think we need to look to see whether this is actually being borne out. But we've seen quite a marked decrease, you can see from this blue line here, with the percentage of claims being granted permission, environmental claims being granted permission since around about December 2020. And that, the authors have noted, does reflect anecdotal experience from our experience in the courts. And I've mentioned a couple of cases there, the UCAF case, the Finch case, which was heard in the Supreme Court last week, initially had to go to, I think, Court of Appeal to get permission. And Wild Justice and Ofwat, which is a case I was involved in fairly recently, didn't get permission on the papers. 2 nearly full days hearings in the High Court and Court of Appeal, but then deemed not to be arguable. And what we seem to be seeing is that the permission stage is becoming a bit of almost like a sort of a dress rehearsal for the substantive review stage, which is not really helpful when it's supposed to be a threshold of arguability. Now, this isn't necessarily to do with costs. There could be other factors in play here, but the forthcoming review of the cost regime does give us an opportunity to perhaps look into this as well. And we would say to the government that they could actually invite views on this as well as costs. And don't worry, Jane, I'm on the last slide now. We're fine. If I can just go to the final slide, which is looking at cases which are ultimately successful for the claimant. Now, you'll see the Pillar of Justice data in red, wiggles around a little bit, but the general success rate for judicial review claims, environmental claims, is around about 10%. We did a comparison there again with non-environmental JRs, and they're about 3%. So again, you can see that environmental cases are doing fairly well. When you look at Pillar of Justice 1 and Pillar of Justice 2, there has been a modest increase in the success rate of environmental claims. So what it seems to be happening is that fewer cases are being brought, perhaps fewer cases are getting permission, but those that do get to a substantive hearing are more likely to be successful. Now, again, we don't know why that is. The forthcoming review gives us an opportunity to explore that. Could be perhaps that people are bringing cases for which they're advised they've perhaps got higher chances of success than perhaps cases that are on the margins. We don't know. Final slide, please. Just a few concluding remarks. Just to say, the lack of a comprehensive monitoring regime is obviously a massive problem here. We need to address that by having a proper monitoring system that enables us to really drill down into this data. What we seem to be saying is that environmental JRs have a good track record when it comes to JR as a whole, but that legal reform, and particularly reform around the cost rules, are having a predictably deterrent effect on prospective claimants. And if that is a policy of trying to deter Aarhus claimants, that amounts to a serious systemic breach of the convention. The forthcoming Aarhus Convention cost review gives us an opportunity, it gives the MOJ an opportunity to ask claimants what they think is happening here, to ask all parties, in fact, what they think is happening here, and to provide some solutions. And of course, the deadline of doing that is October 2024. We would hope that they would do that before that, but that is the long stop. So that is what we're hoping that forthcoming review of the cost regime will achieve. Thank you very much. And I'm sorry to have gone slightly over time. Thank you for listening.
Thank you so much, Carol. That was so informative and really has set us up brilliantly in terms of understanding the report. I'm sure we've got lots of questions. Please open the Q&A function and start. We're going to take questions at the end, so please do start populating the Q&A in time for that. So without further ado, Emma Montlake is from Environmental Foundation is going to help us look behind some of those statistics, looking at some of the case studies that the Environmental Law Foundation have developed as part of the report. Emma, should we pass over to you?
Thank you for that, Jane and Carol. Carol's such a really comprehensive run through of this latest Pillar of Justice report. And I'm very pleased to have a part in this event today, to be able to just represent a small snapshot of ELF's experience. That is really the community voice, I suppose, working as we do with those grassroots communities who approach us for free legal advice. And when, just to give a little bit of context about ELF, when ELF was set up in 1992, prior to, of course, to the Aarhus Convention, by 3 forward-thinking individuals, it was done so to reflect their experience in the field, an environmental campaigner and an environmental lawyer, of this vast chasm of resource inequality that existed between the communities who were looking to protect not only themselves and their public health, but their local environment, as opposed to those who had such deep pockets and were either looking to impact on the local environment or indeed were doing so. And access to environmental justice for all was really at the heart of ELF's establishment. And so then 6 years later, when the Aarhus Convention, or the UK became a signatory to the Aarhus Convention, it really percolated through the organisation. And indeed, access to environmental information, good public participation in environmental decision making, and non-prohibitive access to non-prohibitive costs for environmental access to justice really set the tone for us, and indeed have shaped ELF as it has moved on in the intervening years. So ELF is a pro bono legal charity. We are the only UK charity working directly as we do with grassroots communities. We take in around 300 inquiries a year, and we take all comers. As long as it's environmental and public interest, then we will try and assist those communities with the somewhat limited capacity that we have. And that is really helping communities to navigate their way through very complex legal and statutory processes, and to enable that participation in environmental decision making that we see as such an important pillar of good civic society. And so through all those Aarhus pillars, you can really see how Aarhus does really run through the veins of the organisation. We take many inquiries annually from communities who are looking to challenge environmental decisions, public body decisions, and we're really helping them to understand at those very early stages, what often they have no idea about the tight time limits, and certainly few of them have any idea about the cost challenges involved in environmental and public interest litigation, and of course, it has to be recognised that it is more often than not communities who are picking up these pieces of bad environmental decisions, and of course, once they leave ELF and leave the sanctum of that pro bono situation, then really the full implications of those financial risks are really brought to bear. And we can see as well that, of course, public litigation is incredibly different, is very different from your normal commercial litigation or indeed public law challenges, and does really sit alone and requires that that sort of protective stance that Aarhus brings to the table. As can be demonstrated from today's report, we have analysed our data, and of the significant numbers of inquiries that come to us around judicial review, we see that where we have been able to obtain a positive opinion on the merits of a successful challenge, of those 44%, nearly half of them drop away due to the concerns over costs. And that's not, of course, just the adverse costs, but also the costs of taking judicial review. So I just want to talk a little bit about some of the inquiries. I think it brings to life what it is that really we're talking about, and those really colossal challenges that local people, communities face. And I also just want to note that more often than not, of course, we're confined really to more or less the planning regime for environmental challenges, and of course there's a whole host of other environmental challenges that at the moment Aarhus doesn't cover, and I'll just speak to that a little bit at the end. But first, to come back to those to some of those case studies that we those amazing communities that we work with. And I can never do one of these talks without mentioning the good folk in Boreham Wood around the town and village green and local wildlife site of Woodcock Hill. And it's an interesting story simply because the resilience and endurance of this community to protect this wild and beautiful urban site has spanned decades, literally decades. Going back to the original application for the town and village green, for which they were successful, the community, in the knowledge that they have established and registered a village green, feel that they have become the custodians of this site, and really over the years put their heart and soul into the nurturing and the stewardship, enhancing biodiversity, digging ponds, planting trees. This is a really motivated and marvellous community. They were somewhat alarmed in 2018 when Taylor Wimpey, the owner of the site, withdrew their permission to mow the grasslands, for which the site was a local wildlife site. 2 years later, they received notification that an underused section of the Commons Act, the deregistration of a village green would be sought, and so commenced an enormous process of consultation, and 2 years later we had a 2-week public inquiry, of which ELF was very involved. And a lot of money is being spent at this public inquiry. Whilst we're amateurs, we do have a barrister who is acting on behalf of the local community. But of course, Taylor Wimpey have deep pockets, and we have a very aggressive KC and the best consultants who have put in evidence. Sadly, when the outcome of that public inquiry was that PINS would permit the deregistration of part of Woodcock Hill and the replacement of it with land which had completely shifted the centre of gravity of that relationship with the village green. This replacement land is no longer relative to that community, and of course is unloved and unknown to them. judicial review follows. At first instance, the Secretary of State and the interested party refused to accept that this is a Aarhus Convention claim. So that's a really big hurdle for this community. Without the Aarhus costs protection, this claim will simply not proceed. It's an absurdity that that stance should be taken, as clearly this case is about, in its heart, about the conservation of the environment. They conceded that point, but still, if village green matters come to be challenged, they will have that hurdle to get over in the first instance, whether or not Aarhus cost protection it actually applies. The judicial review, permission granted, it goes to the High Court and is unsuccessful, and now it's on its way to the Court of Appeal. But what is so interesting about that case is not only the long duration of that struggle by the local community to protect this site that they love so well, but also the interplay of cost protection, the difficulty that they experienced originally in getting Aarhus cost protection in the first instance, and literally the tens of thousands of pounds that this community, and it isn't a well-off community, has had to find. I think we're somewhere in the region of 50 or 60,000 pounds where we are now, and that's with cost protection. So it's really challenging for communities. The second matter I want to talk about, which was a particularly heartbreaking matter for me, something from last year, a very small community in Wembley, in Brent, 14 flats, obviously no gardens, but they had this little bit of green space. There's a car park, there's a bit of green space, and a line of mature trees. An original planning application from some years ago was rejected on this site due to the loss of trees, and they felt pretty safe. Brent brings in a new local plan. They have an infill policy, and suddenly this little community are faced with an application for social housing on this green space, and the replacement land is moved to a very busy main road. Now, one of these community members has a severely disabled daughter, and she doesn't want to leave the flat really at all, but she will go down to this green space. We had a good opinion from we had a positive opinion from a barrister. We had a case CFA offered by hi Jane.
1 minute.
1 minute. Offered CFA offered, and still the community was unable to find that £5,000, and the claim didn't go ahead. I've only talked about 2 cases. I have so many more, but I ramble on. So the other thing I just wanted to quickly mention was in respect of an ongoing case that we have with the Aarhus Compliance Committee. Hugh James is acting on behalf of ELF. This is around the fact that private nuisance is not covered by Aarhus. We have this complaint has been upheld, and still we wait for action from DEFRA. We're really struggling to understand how the UK government can be so dilatory in its action. Thank you. I'm just going to stop now.
Thank you, Emma. Thank you so much. Really valuable insights and analysis behind the statistics. And thank you for your accounts. All of the case studies in the report are really well explained in terms of the consequences for those groups. Thank you. Moving on to Katie Takawa from Friends of the Earth. Thank you, Katie.
Right, thank you very much to UCL for hosting this event and the opportunity to discuss this very important report. I'm going to start off by just giving a small overview of Friends of the Earth's contribution to this report before I move on to some of the broader issues relating to the implementation of the convention, and with an emphasis on public participation rights. So just a little bit of framing. This has been alluded to some degree already, but the context for this report and it's being published now, I think it is very important in terms of understanding its significance. We are, as everyone is aware, facing a climate crisis and also a biodiversity crisis, and civil society is responding to both of these crises in different ways, but that includes a mounting tide of climate litigation. And this is very much in response to government and corporate inaction on these crises. So findings, for example, by the Grantham Institute in their report last year found that the number of climate change cases has more than doubled since 2015. And I think they stated that in June 2022, there were around 2,000 cases in total to date. Other institutes, well-respected institutions, have recognized the positive benefits of these climate cases. For example, the IPCC cited this in their report last year, that these cases can encourage greater ambition on the part of governments. So this report, looking at trends in cost protection, or rather trends in environmental cases that are being brought as influenced by the cost protection regime, comes at a very important time. So in terms of Friends of the Earth's contribution to the report, of course, as has already been recognised, this is very much a report that has been led by Carol Day on behalf of RSPB. In this version of the report, Friends of the Earth's main contribution was through trying to bring our insight in terms of the practical experience of these cost protection rules and what they mean on the ground when you are taking cases and going through the legal system. So we included examples of both Friends of the Earth and other claimants examples of where they have faced attempts to vary cost caps, and also attempts to prevent their claims actually falling under the Aarhus cost protection regime at all. And Carol's already referred to our case, which we took a couple of years ago against a UK Export Finance in relation to their decision to provide over $1 billion worth of taxpayers' funds to finance the project off the coast of Mozambique. This was said to be a decision that was aligned with the Paris Agreement, and yet the government sought to persuade the court that this was not an Aarhus claim, that this was a financing decision purely. So I think the other thing that we've really tried to bring to bear with the report is what happens when cost protection isn't there. And of course, this is illustrated very well by the examples provided by the Environmental Law Foundation. But just taking two cases of ours, last year we achieved a victory alongside Client Earth and the Good Law Project. The court found that the government had breached the Climate Change Act in relation to its net zero strategy. And that case, from Friends of the Earth's perspective, was only possible in financial terms because we benefited from a default cost cap. By contrast, when we sought to vary a draconian anti-protest injunction taken out by Quadrilla, the court actually held there that there was no cost protection possible under the rules. And therefore, Friends of the Earth was priced out of court because Quadrilla was threatening us with £85,000 worth of costs. And we very much support the conclusions that have been alluded to by other people, that the Aarhus Convention is not being fully implemented under the cost regime, both in terms of the types of cases that fall under the regime currently and those that don't, including the private law cases. I think in terms of the broader picture for the Aarhus Convention, I think this report needs to be seen in terms of the democratic nature of the Aarhus Convention in and of itself. So the Aarhus Convention is aimed at trying to help secure a right to a healthy environment for citizens. And there are these three pillars to the Aarhus Convention to help secure that overall goal. And they are, of course, right to information, the right to participate in decision making, and the right to challenge decisions through the court or through some other forum for review. But in terms of public participation, the value of this is really emphasized through some of the recitals to the convention, and I've just listed a few of them on this slide. But looking particular at recital 9, recognition that public participation can improve decision making and enhance the quality of decisions that are made. There's also the benefit of accountability and transparency in government decision making, and the importance of integrating environmental considerations into governmental decision making. And part of the means that you do that, of course, is to provide citizens with the power and the right to be in the room and get their voice heard. And of course, Friends of the Earth, as a campaigning organisation and as a grassroots campaigning organisation, we fundamentally believe that grassroots power is essential to effect positive change. So looking particularly at public participation, these rights are really set out in Articles 6 to 8 of the Convention. So there's the need for the public to participate in decisions on specific activities or projects. There's the same need to participate in the preparation of plans, programs, and policies. So that's a step up or a higher level. And then there's, of course, Article 8, the right for the public to participate in the preparation of executive regulations and other generally applicable legally binding rules that may have a significant effect on the environment. Now, two of these articles, Articles 6 and 7, have basically been implemented under our national law. Both of them have come through European Union directives, which are now part of retained EU law in any case. But I'd really emphasize the importance of these in terms of citizens' abilities to stand up for environmental justice. And the Sarah Finch case that has been referred to already is brought on the basis of the Environmental Impact Assessment Directive, which in turn has its source at Article 6 of the Aarhus Convention. And there are other examples that could be made in relation to cases concerning a strategic environmental assessment. And I've listed one there that Friends of the Earth took in relation to the government's national planning policy framework a few years back. But unlike Articles 7 and 6, Article 8 has not ever been implemented in national law. And for that reason, Friends of the Earth has filed, or some years ago, filed a communication to the Aarhus Convention Compliance Committee. This is a UN body, and we made this communication back in October 2017, and our case is based on a breach of Article 8 and Article 3. Article 3 is about setting a consistent framework for these other rights. The example that we give in this communication is the draft European Union withdrawal bill as it then was. Now, obviously, that has been enacted some years ago now, but we have pursued this case because we see it as establishing a very important point principle in terms of the right for the public to have a say in the preparation of draft bills that may affect the environment in a significant way. And the key thing about this bill was that it was not published in any form prior to entering Parliament. Now, the ACCC, the Compliance Committee, made a preliminary decision on admissibility of our communication back in December 2017, and we've since had a substantive hearing before them in September 2022 last year. So we are waiting for their draft findings. Our case centres on several key issues, but first of all, we say that Article 8 was engaged when this draft bill was prepared. that the government, when it drafted this bill, was a public authority for the purpose of the convention. We've had pushback from the government that this is about undermining parliamentary sovereignty. That is not anything to do with our case, because at the point of when the government is drafting the legislation and before it is entered into Parliament, it is acting in an executive capacity, and that we feel is supported by the Aarhus implementation guide, which says, which refers to this point of passage between the executive branch and the legislature, and I've included a quote in this slide. Secondly, the Article 8 is not, as the government is maintaining, limited to secondary legislation. That is an unduly and unjustified restrictive reading of the Aarhus Convention, which makes no such reference. And as the guide says, Article 8 refers to rules, and that is clearly a broad term, and it should be used in, it's being used in its broadest sense. And therefore that again supports our argument that Article 8 was engaged here. We also believe that the threshold test for impact of this bill was passed, and the test is whether or not the bill might have a significant effect on the environment. And we think it's clear that at the time that the bill, at the relevant time when the bill was being prepared, that was obviously the case, given that most of our environmental laws are derived, and certainly were derived then, from European Union legislation. And there are various other examples that one could point to, such as the fact of Brexit meaning coming out of the common fisheries policy, for example, coming out of the European trading scheme on emissions. All of these give rise to the potential for a significant effect on the environment. The other pushback we've had from the government is that there was, regardless of whether there needed to be, there was effective public participation, and they point to things like the fact that there was a referendum on Brexit. And we say that the key thing is that Article 8 requires effective public participation, not just any sort of participation, and that's something that's quite a serious obligation, and it means that the draft bill should have been published and available to the public to comment on prior to it being introduced into Parliament. And as I've said, we also maintain that there is no consistent framework for ensuring public participation happens when draft bills are prepared, given that there's no implementation of Article 8. And what happens is that sometimes draft bills that may have a significant effect on the environment are consulted on or are subjected to some other form of public participation, but that doesn't always happen, and it didn't happen here. So just to wrap up then, and putting this back into this broader context, we all know we're facing a climate crisis. We have the record-breaking temperatures of 40 degrees last year, to make that point very clear, and the frequency and magnitude of those sorts of extreme weather events is only going to increase if the global community does not take the urgent steps necessary to combat the climate crisis and limit global heating. In this context, we absolutely must safeguard and facilitate access to justice, and that includes ensuring that it is something that is a right for everyone as opposed to a privilege for those who can afford it. And we fundamentally need a system where environmental claimants are not priced out of court. That, on the basis of the Pillar of Justice 2 report, is not what is happening. And finally, we must facilitate and safeguard public participation in environmental decision making. And that is the reason for us bringing our Article 8, Friends of the Earth Article 8 communication. I just point to some further information in case it's of interest. All of the Aarhus Compliance Committee's communications from the public are available on this website. That includes the one from Friends of the Earth, also another one on Article 9 brought jointly with RSPB, Friends of the Earth Scotland and Lee Day, that concerns the standard of review in environmental cases, which is unfortunately another obstacle to access to justice. and also this 194 communication from WWF and others, which also concerns Article 8 with the example of free trade agreements. Thank you.
Katie, thank you so much. That was so informative and so interesting to really get into the detail of the case being brought by Friends of the Earth. And we got to an hour without mentioning Brexit before you did that. So I think we've done very well. Thank you so much for those legal insights from Friends of the Earth. We can now open for questions. We're running a little bit over, but I'm really keen to take any questions from our audience. There was a good question from Dan concerning the role of legal technology in this area, given the chasm between the existence within Aarhus of rights of participation, but also the practical difficulties of their implementation. I haven't got probably the exact wording of that question because it's been taken down. I don't know if Dan has had to leave, but I think it's an interesting one. You know, I suppose what's behind that question is thinking about the broader legal developments, broader legal landscape in terms of securing the rights within Aarhus. Does any of the panel want to jump in on that question? I've got another question if clarification is needed on that one.
I think it would be helpful, Jane. Yes, if I don't, so I think it's my fault. I think I tried to ask Dan if he could clarify what he meant by legal technology. I think we weren't quite clear. Did he mean kind of AI or something else? So
yeah, I was wondering whether it was satellites or AI. Oh, here, look, here, a very broad definition, but would include generative AI, document handling, etc. Very interesting question. We've all grappled with Zoom this morning. That's been quite hard enough. So legal technology is a really interesting question. Anyone?
I can make a start if that.
Brilliant. Thank you, Katie.
I mean, I think in terms of, first of all, document handling, I think for unrepresented, and we are increasingly seeing unrepresented claimants, the electronification, if that's the correct word, of judicial review and court cases generally can present real challenges to people who aren't used, for example, to preparing court bundles and that sort of thing, with everything being submitted online. I think this is especially the case for people who, for whatever reason, are less familiar. And I think there is a growing divide really between those people who are very technologically aware and on top of things, and those who are less confident. So this might be, as a generalization, people who are older, for example, but then we're seeing a lot of people who are older who are very concerned about their grandchildren, for example, and wanting to you know, be engaged in tackling the climate crisis in that way. So I can see a potential negative in that way for certain groups. I think in terms of AI as it currently stands, I don't really see a very clear role for it in terms of leveling the playing field in terms of, you know, preparing pleadings and things like that, because I think that is still something that is very, very specific. So I would say that at present, I can't see an obvious and clear role to equalize the scales in that way. That's my view. Carol.
Yeah, I just wanted to add, I mean, Emma may want to come in on this as well. I mean, just picking up on Katie's very good point about, you know, sort of the inclusivity of that process. And I know that one of the reports that ELF produced in 2009 looked into access to justice and particularly focused on the impact on disadvantaged communities. And I would imagine, and it showed there was, as we perhaps may have expected, you know, a disproportionate effect on those members of the communities. And I would imagine they are probably the people who are not going to have also, you know, I mean, I really struggled to get on this Zoom call. I think, you know, the sort of point about old people is a really good one, but also the point about people who, you know, just aren't simply going to have the means to have the access to those kinds of technologies. And the sort of people that Emma was, you know, sort of probably routinely approaching ELF for help, I would imagine are going to be people who may not have, you know, sort of access to all of those sorts of facilities too. So I think, you know, I think there may be a potential problem there.
Dan, thank you for that. That's given us lots to think about, and something which will be
sorry,
useful.
Jane. I was just going
Emma.
to just going to come in there, and so my video is not working. I don't know what's going on. So, you know, talking about technology being a barrier to access is being well demonstrated. But yeah, no, absolutely. And I also suspect that you know, there's probably some regionality as well in these access to justice issues, where we have you know, lower income communities. Certainly from my sort of very basic sort of analysis, I would think that there were issues there, and as you know, more people, as we move towards those technical solutions, I think undoubtedly people will be cut out. It's just, yeah, undoubted. So,
that's great. Thank you. Dan's got back to us to say current application likely to be limited, but with people using smartphones, etc., it could be of use. I'm going to go. Thank you for that, Dan. I'm going to go to a question from Felice Hemon, and the question is, where are we? About local authorities. I feel that on the whole, most local authorities have embraced Pillar 1 through access to information, and 2, consultation in decision making. But I'm curious how they could assist with Pillar 3, access to justice. Is judicial review the only way? Any thoughts on that question? It's very interesting. Carol.
Yeah, and I don't know whether anybody else wanted to come in. I'm not sure it's a way in which they can assist, but of course there's a big question around the planning system in terms of access to justice and a third-party right of appeal. There was an interesting communication that was taken to the Compliance Committee in respect of Northern Ireland, where the Compliance Committee found that the absence of a third-party right of appeal was problematic in terms of the UK's compliance with Article 9 of the Convention. Now, I'm not sure that's something that the local planning or the sort of responsibility for looking at that, and whether that's something that needs to be addressed lies with LPAs. But yeah, so I don't know. I mean, it's a really good question, because I can't off the top of my head think of any ways in which they can massively help with that particular third pillar. I don't know whether anybody else can on the panel.
Emma or Katie?
I was just going to say, sorry, video is still not working, that I'm not entirely clear that that local authorities have properly dealt with pillars 1 and 2, actually, and I know that there has been a lot of work around that, but I'm just thinking, for example, in particular with local plan making, and how excluded local people feel from that process, which is an incredibly important part of that sort of democratic planning process, and find it very difficult to participate. It's very hidden. So yeah.
I agree with what Carol has said in terms of it being quite hard to see how local councils could directly have a bearing on Article 9 and the or Pillar 3. I think, you know, issues like the cost regime and what comes under the scope of that is something that's going to be set at national level rather than local. I suppose something that councils could be aware of, because they are sometimes defendants in challenges over environmental cases, is to think, you know, very carefully, as that's something that I think we're trying to highlight in this report, about whether it is appropriate for them to be applying to vary a cost cap, for example. That's more of a policy position that they could be taking internally. You know, in the spirit of the convention, and in the spirit of the importance of these rights, whether or not they think that the claimant is right to be taking the challenge, whether they think there's much merit in the challenge. It's the basic importance of access to justice as a significant in and of itself.
Katie, thank you. That's great. hopefully that has been a good response. Moving on to, so thank you, Felice. Let's move on to Jane Paul. Her question is, for small local rural community campaigns, one big barrier is the cost of gathering scientific or technological evidence to support a claim, even before legal action. So I suppose the question here is looking more broadly at financial barriers. Is this something which is indeed significant, or might be included within a consideration of concerns about finance? Emma, that might be, is that up your street?
Yeah, I mean, you know, from ELF's point of view, the professional network that we hold so dear and is of such importance to us does include scientific and technical experts. So there is a route through ELF to obtaining some technical assistance, though the membership is quite small. But yes, I mean, certainly without ELF's assistance or pro bono assistance, expert evidence or review is very expensive, and can form such a fundamental part of any challenge that it certainly does ramp up the costs, and of course there's no protection for that. So it is just another large, or can be another large element of those costs for communities. It's a tricky landscape for sure.
Thank you, Emma. That's really helpful to get the practical perspective. Thank you very much. Hopefully, Jane Paul, that addressed your question.
Can I just
sorry, Katie.
Sorry. I mean, this isn't a full answer to this, but I think, as Carol has highlighted, the Aarhus Convention is about costs being not prohibitively expensive for claimants, and I think this might be addressed to at least some degree if we didn't have this 35k cost cap, you know, limiting recovery for defendants. There might be some scope if it was assessed on it, you know, under the normal court process, instead of being capped at this amount, to recover some costs relating to expert evidence through that. But that's, you know, that's all dependent on taking a claim and it succeeding. But that's one thought on that anyway.
Katie, thank you for that comment. Thank you. Can I abuse my position as chair? I'm sitting in a university. What can we do in terms of legal education, or even earlier? I know that Emma's been involved in some interesting work getting Aarhus into schools and so on. But what do we do as legal educators? Would you know, maybe taking Michael Moses' approach, just one thing in terms of legal education? Anyone?
I can go ahead. I mean, I think it would be useful for something as the Aarhus Convention to be introduced at, or awareness of the Aarhus Convention to be introduced at school age, so that there is some sort of understanding of there being rights to environmental justice. Certainly I'd never heard of it until I started studying environmental law. I think even within the broader legal profession, there are plenty of people working in other areas who've never heard of it. But I would see it as, given the importance of it and the democratic value of it, I would see it as something that could be, could and should be included in, you know, broader education over citizenship and, well, perhaps citizenship isn't the right word, but the political system that we have and the rights of citizens to, you know, challenge abuses of power, perhaps in the context of discussions over the separation of powers and how this country functions.
Brilliant, thank you. So good point to end. Carol.
Yeah, no, sorry, I was
didn't mean
waiting
to cut you off.
Emma may want to come in on that, because obviously it's sort of massively her sphere, but and I'm going to say a few things which I hope aren't stealing her thunder. But yeah, I mean, it's really just about, the first thing is actually, you know, what is Aarhus about? It's about, you know, it's that kind of Article 1, you know, sort of central heart of the convention about sort of, you know, the right of all of us to live in a clean and a healthy environment. It's about a love for the environment. And I remember when I started out in my career in nature conservation, I worked for a small county wildlife trust, and we used to go into schools and build, you know, wildlife areas for them, and you know, do sort of talks and presentations, and you know, the importance of getting in there at that really early stage and just fostering a love for the environment. That's what it's about, because probably it's a little bit difficult to be talking around, you know, sort of rights of engagement and whatever, but if you can just get that basic love of it embedded. And I know certainly at later stages you have the ELS University Clinics programme, which of course this is how we got this report written, is because one of ELS Clinics students from UCL was interested enough and keen enough to actually sort of undertake the statistical analysis for this report. So all sorts of amazing things can come out of that. But I think also it goes back to what Emma was saying about her case in Brent with the lack of green space, because the more we lose these spaces, the more we just completely losing touch with the environment. And it's incredible, you know, the number of developments that we're seeing now where there's hardly any trees integral in them. It's really worrying, particularly where I live in Greenwich. You know, they're just huge developments with absolutely no green space built in at all. And the further we get away from nature, the further we're going to get away from any sort of citizen empowerment. So I think, you know, all levels of education, we need to you know, put the measures in place to get that engagement with the environment, and then you can build out from there.
I'm pleased we've got a shout out for the ELF network there. Thank you. Emma, unless you want to come in, I realise that we're running a little bit over. Is that all right if we wrap up?
Yeah, no, I was just going to say something very, very briefly. I mean, just to completely endorsing what everybody has said, but I'm involved in a local schools initiative in my hometown, which is looking to facilitate and enable environmental action by young people. And it is really, I think, especially in this time of climate change and global heating, young people are really being pushed to the forefront, and to enable them to have a voice. One of the big points about this thing I'm involved in locally is teaching young people the skills of citizenship that they will need going forward, as they look to have a voice in the future that is looking so very frightening. So yeah, absolutely, getting to young people early, I think, is incredibly important. And Aarhus is kind of a beautiful story as well. I mean, you know, I feel that its 3 pillars are you know, are of such worth and substance that, you know, that it might be that young people would understand what it is to participate in decision making.
Brilliant, thank you, Emma. Thank you. I'm just going to wind up now by saying a huge thanks to all the panelists, Carol Day, Emma Montlake and Katie Takua. I think we better wrap up, and thank you very much. I'm looking forward to seeing all of the outcomes of the report going forward. Thanks very much. Bye-bye, everyone.